Today, we will discuss the legal necessity of so-called Blue Sky Memoranda in the context of securities law and small business investment. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. Our firm website is www.cummings.law. A Blue Sky Memorandum is a formal legal analysis that maps the state securities law obligations applicable to a private placement. Issuers often focus on federal exemptions such as Regulation D, as in dog, but state blue sky laws, as they are called, continue to impose notice filings, fees, legends, and other obligations that must be addressed. The memorandum catalogs these rules on a state by state basis and connects them to the issuer's specific facts, including investor residency, security type, and offering structure. It therefore operates as both a legal and risk assessment and an operational checklist, identifying exemptions, filing deadlines, payees, legends, commission restrictions, and other requirements that guide management, counsel, and placement agents. Without it, even straightforward raises risk rescission claims, enforcement actions, and loss of exemptions. A common misconception is that federal Regulation D preempts all state regulation. While some exemptions do preempt substantive regulation, states retain authority to require filings, fees, and to enforce anti-fraud provisions. For example, Rule 506 offerings are federally covered, but states often mandate notice filings and fees tied to in-state sales with deadlines as short as 15 days. States also interpret the word offer broadly, meaning a single pitch or even a webinar can trigger obligations in a state where the issuer has no presence. The memorandum analyzes these jurisdictional nuances and ensures federal preemption is leveraged correctly and efficiently while respecting state powers. The memorandum is not a template, but instead a tailored document anchored to the offering's overall structure. It addresses the federal exemption strategy, implicated states, exemptions or notice requirements, Form D and state deadlines, filing platforms, legends, and fee schedules, among other things. It also analyzes resales and transfers, marketing restrictions, finder rules, solicitation limits, and integration risks. It translates technical legal requirements into actionable concrete steps for finance and investor relation teams. Any offering crossing state lines from convertible notes to real estate syndications would benefit from such a memorandum. Even single state offerings can impose escrow or suitability rules not found in federal law. A missed filing, even on an insubstantial raise, can create rescission risk disproportionate to the capital involved. State notice filings vary. Some require a Form D, consent to service of process, and state-specific forms with fees based on amounts raised. Deadlines differ, with some states requiring pre-sale filings, others post-sale filings, and some even demanding renewals. Fees may be flat or scaled with minima, maxima, or surcharges. The memorandum specifies these calculations and defines what constitutes a sale or offering, or requires an amendment such as price changes or new securities. Without clarity, issuers risk substantial noncompliance during routine adjustments. Several myths persist. Federal preemption, as I said earlier, does not eliminate state level obligations, and accreditation does not excuse filings or verification requirements. Using so called finders who receive transaction based compensation can be treated as unregistered broker activity, tainting the exemption. General solicitation under Rule 506B is prohibited, while under 506C, it is allowed but requires rigorous verification. Issuers also overlook integration risks when multiple offerings close together. That is a major pitfall. The memorandum anticipates or should anticipate these pitfalls, therefore, hopefully preventing costly and sometimes irreversible mistakes. Every state enforces anti fraud rules alongside Federal Rule 10b-5. Boilerplate disclaimers do not insulate against liability for misstatements or material omissions. Some states define materiality more broadly and allow rescission claims under lower thresholds, and statutes of limitation do vary. A memorandum should align disclosures with state expectations, advise on risk factors, and ensure financial statements and projections are defensible. It should inform issuers of state-specific nuances and integrate those retention policies together with investor communication strategies. Integration risks arise when multiple offerings are treated as one financing, potentially altering exemptions or disallowing them altogether. This risk is heightened with rolling closes, switching between 506B and 506C, or layering in creative convertible instruments. The memorandum should coordinate timing and verification protocols to mitigate this risk exposure. As offerings expand to new jurisdictions, each new investor can trigger new filings, fees, and legends. The memorandum creates a phased plan aligned with the RAISE timeline, instructing issuers on tracking residency, monitoring thresholds, and queuing filings before closing. Legends and resale restrictions vary by state, requiring specific language on certificates or book entries as the case may be. Secondary transfers may trigger compliance obligations even among accredited investors. The memorandum should catalog legends, it should set transfer procedures, and it should integrate Rule 144 and stop transfer practices. It should also establish cap table hygiene early on to prevent non-compliance resales and to advise particular investors to engage counsel. Compensation pitfalls are common, as I alluded a few moments ago. Paying transaction-based compensation to unregistered intermediaries risks rescission, enforcement action, and future ineligibility. The memorandum outlines permissible compensation structures, intermediary due diligence, and contractual protections and indemnifications. It also addresses employee, director, and service provider issuance, including suitability and related party disclosure requirements. These issues are often overlooked in informal raises, but formal structuring prevents problems later in audits or exits, and they do arise all the time. Real estate syndications and real estate funds face additional state scrutiny. States may require escrow until minimum raises are achieved, special risk factors for blind pools, or suitability standards for special populations such as retirees. Funds must also address overlapping investment advisor rules with exemptions tied to assets under management and client counts. The memorandum integrates offering compliance with advisor obligations to avoid gaps. Sector and vertical specific tailoring ensures investor questionnaires, subscription agreements, and risk disclosures meet state specific requirements and expectations. Evidence of compliance is as important as compliance itself. Regulators, buyers, and underwriters examine records, including subscription agreements, accredited verification files, Form D filings, state notices, wire records, and even marketing materials. A memorandum prescribes retention frameworks to ensure the inevitable audit readiness. This documentation shortens diligence cycles, at least it can, when implemented correctly, and can further reduce indemnity demands in exits or financings. Embedding compliance into day-to-day workflows enhances credibility and reduces friction as capital needs evolve. Missteps occur, such as late filings or missing legends, and these must be addressed. The memorandum outlines or should outline remediation options, including rescission offers, amended filings, and penalties. Some states allow cures, others evaluate good faith on a case-by-case basis. Rescission offers are not always advisable as they can toll statutes, affect tax treatment, and create additional burdensome disclosure obligations. Therefore, experienced legal counsel is needed to weigh remediation strategies carefully. The memorandum ensures remedial steps should be taken proactively and documented thoroughly. As I'm sure you are noticing by now, private placements involve a complex latticework of requirements. Minor details, such as whether a trust is revocable or whether a webinar replay is made public, can materially and indelibly alter compliance. Experienced securities counsel integrates securities and tax considerations, tailoring the memorandum to anticipate secondary effects. The cost of professional guidance is minimal compared to rescission exposure, impaired future raises, or failed exits. The memorandum, therefore, is not theoretical, but a practical deployment tool and a set of guardrails for decision making, allocation of responsibility, and defensible and documented compliance. To initiate compliance, issuers should inventory investor geography, align on exemption strategies at the outset, and confirm marketing plans. Counsel should then draft the memorandum, building a filing calendar and coordinating budgets. Ongoing updates are essential as investor bases and offering terms evolve. Assigning internal ownership, often to the CEO, CFO, or general counsel, ensures that the memorandum retains current information, that deadlines are tracked, and that counsel is consulted on an as-needed basis. Treating the memorandum as a living document helps to ensure compliance and that this compliance will scale with the raise and subsequent raises, and that the issuer remains prepared for diligence and regulatory review. Again, my name is Chad Cummings, and I hope that you found this information useful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.